Under the Mississippi law, abortions are illegal after 15 weeks. After nearly 2 hours of arguments, all 6 conservative justices seemed to be in favor of making it a state issue. Justice Brett Kavanaugh argued there'll be different access in Mississippi and New York, Alabama, and California. Kavanaugh went on to say that the court, like the Constitution, should be scrupulously neutral.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion. And they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral.
And earlier this month, the court heard arguments on a Texas abortion law, which bans abortions after 6 weeks before many women even know that they are pregnant. I have a special guest with us this afternoon. I'd like to welcome constitutional lawyer Jeff Lewis. Jeff, happy to have you on again. Thank you so much for your expertise. The very first question out of the gate, we know that we don't expect to hear the full ruling until June, but in the meantime, what are the main takeaways and what do you think the likelihood is that this Supreme Court will uphold the Mississippi law?
Well, what I was listening for today was some indication that any one of the 6 conservative justices was going to give some respect to the precedent of Roe v. Wade. And I didn't hear any hints or any questions from those 6 justices that suggest they're going to affirm Roe v. Wade. That's the biggest takeaway.
And let me ask you, Jeff, because I agree with you. And the thing that I noticed is I felt like, and I don't know if I read this exact wording, so forgive me if I don't say it the way that you might have thought it was intended, but really that they wanted to focus on the Mississippi law. And that law is the one that bans the abortions after 15 weeks. And then there was an underlying current, I felt, of saying, we're not addressing the constitutionality issue, right? We're not addressing Roe v. Wade and whether or not a woman has a constitutional right, which currently women do, but rather we're looking at this narrow issue. But doesn't looking at that narrow issue potentially really take away from or erode Roe v. Wade?
That's exactly right. You know, I think the justices were searching today for a graceful way of allowing this law to stand in Mississippi, yet avoid directly tackling Roe v. Wade because it's been on the books for 50 years. And there is no graceful way to say that as an institution, the institution was wrong 50 years ago.
Let's listen, because we have some of the argument, specifically Sotomayor talking about a stench on the institution.
This is a hot, difficult issue for everyone. That's why it belongs to the people. And I think the conclusion the court drew from that it couldn't provide a good enough example, that it would look unprincipled, those conclusions were, with respect, Justice Breyer, mistaken. And the last 30 years has not seen any calming of that. It's been very different than some of the court's other controversial decisions that have seen much more calm.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged. You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes. of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
All right, please tell me, Jeff, if you would, what's your reaction to that piece of her commentary and question?
I think she was spot on. You know, the public is not dumb. If Roe v. Wade is overturned as a result of the appointment of 3 justices by President Trump, you could see renewed calls on the president and Congress to increase the number of seats on the Supreme Court. The public will not stand for a partisan Supreme Court.
And I just had to stop. I was just looking at the picture, and it's such a great picture to show us all of the associate justices and the presiding justice on the Supreme Court of the United States of America, and their decisions they make affect the rights of every single one of us. Let's talk a little bit. I want to pivot. Amy Coney Barrett spent a lot of time during this, or an amount of time, I should say, talking about stare decisis and how she interprets that to apply in this case. Could you give us a fairly quick lesson in constitutional law and what that means and how that was being treated by her in this question?
Sure.
I don't know if you're able to hear me, but yeah.
Sure, yeah. Oh, I'm sorry. I thought you were going to play the question. So,
oh, no,
look,
I'm sorry. Go ahead.
Yeah, the doctrine of stare decisis is that Supreme Court decisions mean something, regardless of who the actual justices are occupying those 9 seats, that it should mean something, and you shouldn't come back and question and re-question cases just because you disagree with them. And you heard a lot of talk today about super cases or watershed cases that have profound societal impact when the Supreme Court makes a decision of profound widespread impact. And so the doctrine of stare decisis says there's certain decisions we should respect, and once they've been decided, move on.
And in this case, it is obviously Roe v. Wade, and we know that that was a case in 1973, and then we know that that case was affirmed, and I think it was 1992 Planned Parenthood. And so the fact of the matter is it's already been decided. It's a constitutional right. Do you think, Jeff, that that constitutional right is going to be protected by this particular Supreme Court?
No, the Supreme Court, pretty clear today, announced it was not going to uphold this right. So one of two things is going to happen. Either the court's going to say we were wrong in saying that a woman has a constitutional right to an abortion, or we were wrong in saying the state's interest in protecting an unborn child is less than or equal to the woman's right to an abortion. But you're going to see a profound change in women's reproductive rights when this decision comes out close to June.
And this is why everyone should pay attention to what our Supreme Court is deciding on cases. They affect all of our rights. Jeff Lewis, thank you so much for being with us and all your expertise as a constitutional lawyer. Greatly appreciate it. Of course, always want to thank all of you at home for joining us. This is it for me. Don't go anywhere. Michael Ayala is back in the anchor chair next, and he will have the latest on the Ghislaine Maxwell sex trafficking trial in federal court. We know that cameras aren't allowed, but that's why you're not going to want to miss any of the information about everything that has happened in that trial today. Up next, Michael Ayala here on Court TV, your front row seat to justice.